1707 by Sabine Corio-McNeill, requesting abolition of adoption without parental consent, and petition 2468, 2013 by Roger Fox from the UK on the practice of forced adoptions in the United Kingdom. I believe that the petitioners are present in the room. Where are you?
Over there.
Over there. Welcome. Welcome. And I'll give the floor straight to you. We did receive a letter from the minister. It's dated on July 2014. It has been circulated. We got it now, so it's been circulated to you now, so you have it in front of you. By that, I give the floor to you, Mrs. Sabine Corio-McNeill.
Okay. Good afternoon. My name is Sabine, which is German, Curio, which is Slavic, which explains my passion. And even though I was married to a Scotsman, I retained my German nationality. I'm here on behalf of the Association of Mackenzie Friends, which I co-founded and whose website I publish. Mackenzie Friends are lay legal advisors who are helping victims, especially of family courts, at any and all levels. We, in particular, work in the interest of the public in general. We don't get that involved in individual cases and custody cases, but we have submitted a study which we described as the systemic patterns of child snatching and forced adoptions in the UK to the March Committee. And since then, a few things have happened, above all an international conference on child removal proceedings in Prague. The March Committee was accompanied by 30 people, 30 victims, parents who had lost their children, who put high hopes on my presentation on their behalf. So the submission was not only a report, but also a dossier of online evidence, which comprised 12 pages. Plus, we were encouraged to submit numbers of signatures, and I put a total of 4 or 5 petitions together, which at the last count amounted to over 8,000. At the time, the old committee members promised a fact-finding mission, and there are a lot of parents out there who are still waiting and hoping for that to happen. My 6 minutes of passion were recorded by a number of TV stations, and I got a letter from the European Commission which said, sorry, we cannot intervene. Likewise, the Petty Committee was informed that the Commission cannot follow up. But at the same time, I had to listen and talk to the Portuguese parents whose 5 children had been taken and who were arrested by Lincolnshire police for belonging to the forced adoption campaign group. When they now see their children once every 2 months, they are treated like criminals. The 2 youngest ones are supposed to be adopted. On April 17th, i.e. a month after the committee meeting, the consul whom I had met and an attaché of the embassy met with Lincolnshire Council, and the children were promised to be returned to a Portuguese institution. That still has not happened till today. However, the father since then has lost 2 jobs because the social workers call the employers and tell them whatever they want to do. That is the reality. The Welsh father, who had been with us also in the public gallery and who was absolutely desperate to see his children, he was punished for having been in Brussels by not being allowed to see his son on his birthday. He tried to kill himself because of that. And his suicide attempt is not the only one in that particular area of Wales, which is Carmarthenshire. My Mackenzie friend, who accompanied me in Brussels, has had to endure 2 more suicides, and he suspects and knows that and how the coroner is involved in covering the facts up. John Hemming MP has tabled an early day motion about these punishments and that English subjects get punished for travelling to Brussels. He suggested that I focus on the concerns by the international community. The fact that foreign children are to be adopted by UK subjects, being exposed to a different language possibly, different religion, different culture, and that was highlighted at the International Child Removal Conference in Prague, which was initiated by a marvelous Slovak lady who got involved in the war case, which has become famous, where I had been talking to the father, where 2 boys were returned just before the adoption, without the consent of the parents, after 920 days in care. John Hemming has the facts about the fact that over 100 families have fled to Ireland, and he suggested that maybe the audience may have heard about the case of Ashia King, who's the little boy who has cancer and whose parents were put into prison. So there is a conundrum. The UK chases UK mothers and their children in foreign countries, and foreign mothers who visit the UK are not safe to have their children in the UK. The Prague conference reminded us of the resolution that Council of Europe members had taken in 2012, which subscribes to the EU Convention on Human Rights and the UN Convention on Child Rights. But if you've come to London, you may have taken the tube where you keep being reminded of mind the gap. This is the gap between reality and the law and what is practiced. A huge gap. And I seriously hope that the Commission will take note, because I get the impression that they do not have enough contact with victims, and that's why I'm grateful that the Petition Committee at least listens to victims.
Thank you very much. And by that, I'm happy to give the floor to the Commission, and I believe that Natalie Stockwell is here. Please, the floor is yours.
Thank you very much, Chair. I would like to thank Mrs. Curio-McNeill for her very detailed and clear presentation once more. As you've said, yes, these issues have already been raised and discussed at the March meeting of the Petitions Committee, and they are of great concern to the Commission. All policies and decisions concerning children are to be taken with one prime principle in mind, and this is the child's best interest. So I will not repeat what has already been mentioned by my colleagues in March, at the March meeting, and in the many emails and exchanges you had with my colleagues about these issues. And I will not expand either on the response, the official response that has been given to your petition. I can imagine that you really don't want to hear this again. And believe me, it would be a frustrating exercise for me too to do so. What I would like to say is that given the gravity of the issue, we have, competence or not, contacted the British authorities on this, and so has, as you know, the Petitions Committee. The UK authorities, and I'm referring here to the letter mentioned by the Chair distributed today, have assured us that in all cases the child's best interest is the overriding factor. Children should live with their parents whenever possible, I'm quoting, and families should be given extra support to make this possible. Now, I know and I understand that this is not maybe your experience, and what I would like to offer, and the date has already been set with my colleagues, is a meeting to discuss this in details. My colleagues responsible for children's rights will be present to discuss these issues, mainly also in view of the guidelines that we will be issuing on child protection systems. I will say a bit more about that later. We have also invited to this meeting our colleagues in charge of the revision of Brussels 2A. So be assured that with this meeting we will really explore all possible avenues and discuss them in depth. Thank you.
Thank you very much. And now I open the floor for colleagues, and I have Mrs. Sakorafa first of all.
Thank you very much, Madam Chairman. When we get into affairs affecting children, I think that we would be wise to look at the principles which apply globally, one of them being that there is no link, there's no relationship more sacred than that between children and their parents. And I'm sure anyone here who is a parent will concur. And we have got to find ways, any ways possible, for us to provide assistance in such cases. Now, there are efforts being made to make sure that relationship is maintained, even when parents are put in prison, when they're sentenced to prison, even though the rest of the family is not responsible or at fault. And I think that that principle will help us and provide us with guidance so that the best interests of the child is always preserved and maintained. This is also true. This is also the case when we, in all of the areas where the interests of the child are involved, we must make very sure, particularly in the Petty Committee, in our committee, that we look at the broader picture, as broad as possible, rather than trying to narrow things down to the exclusively legal dimension. So we've got to look at this in the broadest possible sense and make sure that we have a proper sense of the different jurisdictions which apply in connection with the family and the rights of the child, because there are instruments which are available, which we have access to in this committee. We can call for pieces of legislation to be crafted and adopted. And this is interesting as we look at the reply from the Commission. I think that it is going to be the last paragraph before the conclusions here. It talks about the parents concerned, where adoption takes place without their approval. Now, we know that very often in these cases with migrants, there is an economic problem, and they may not have the money to initiate legal proceedings to the Court of Human Rights, for example. And I hope that through you, Madam Chairman, that I'll be able to impress this upon the Commission. And we next have the next petition coming up is by Mr. Yiannopoulos, and I've been looking through the petition, which is, if you like, on a related area. It has a response from the Minister of Justice in Cyprus. Now, I know that it's always very difficult when the European Union is not able to intervene where a country is not covered by regulations and directives. However, given the anxiety of the parents and the parent here, I think that we must apply that principle of looking at the best interests of the child and, as it were, the two parents in each case. And it's important that we try to always put the focus on the child and the parents. Thank you very much.
Mr. Yiannopoulos is further down the agenda, but we will also discuss his difficulties and his issue later on. Now I'll give the floor to Mrs. Kirsten Darling.
Thank you very much, Chair. First of all, I'd like to say that I think we should recall the decision which was made first thing this morning around the idea that petitions which relate to children should be fast-tracked through, in some way, through the committee. I think that's really important and a really important decision. And I'd also like to acknowledge, putting this into a broader context in the UK, the public concerns in the UK related to historic child abuse and the situation in care homes in Britain. And I think there's a need for much deeper and much quicker inquiries in the UK into some of the broader questions related to child protection across the board, and that's our government's responsibility. Clearly, this is an extremely emotional subject, and I think we have to take the responsibility that comes with that if there is any evidence of problems associated with the adoption of children, they have to be taken extremely seriously. And the rights of the child demands that the child's best interest is paramount in any decision-making process, and I think that's absolutely right. So I was pleased that the UK government had responded to the previous Petty Committee's concerns and had set out what is essentially a legal perspective on the UK. However, I think the number of petitions suggests that there is something going on which is worrying. And I agree with the last speaker that we need to place this in a broader picture, not just the UK, but how it fits into the European framework across the board in respect to child protection, adoption and care processes. So whilst I know the Commission's view, and I take the points of the Commission, that this is largely a national competence, I think that there really has to be a first request that there would be a more detailed investigation into what's going on in the UK. And I think it's a great initiative from the Commission to hold and pull together a meeting with those concerned to do that. This is very sensitive, and I think we have to deal with it in a very delicate manner, and I think there needs to be a more detailed response from the UK government, particularly in relation to some of the cases, and I think that will fit into some of the investigations which are ongoing on child protection in the UK. And I think the dimension of the European Convention of Human Rights should be addressed as well. That's the first point. The second point is, I'll be much quicker, I promise, is that I think there clearly is a question about the responsibility of the EU when it comes to cross-border cases. And currently there's no mechanism at EU level to deal with the implications in terms of adoption and so on. And so my second recommendation would be that we seek a legal opinion from the Legal Affairs Committee on the potential need to address these situations of cross-border child protection and adoption within the Brussels II regulation. And I think that should fit into the ongoing review of the Brussels II regulation, but I think we should keep this case open and hear what the results of that legal opinion are. Thank you.
Thank you very much. Now, Renate Weber, the floor is yours.
Thank you very much, Chair. I confess, with the occasion of discussing this, is the first time that I heard about such things in the UK in 2014. When thinking about these kind of adoptions, I was definitely much more inclined to think of Argentina or the Chile of Pinochet, where several thousands of children have been forcibly adopted after their parents were disappeared. But yes, although it's something extremely delicate for a UK member of the European Union, in 2014, I think that indeed a thorough investigation is important in order to very, very carefully and correctly address the situation in each and every case. I also confess that I personally have a problem I have always had with the idea of the best interest of the child, something which is extremely subjective and depends on who is deciding what is the best interest of the child. Maybe, I don't know, a more accurate criteria is not to endanger the life and the correct growth of a child. But I have two very concrete questions because I really want to understand better. When we are talking about adoption, does it refer to the classic adoption, or it's placing children in foster care? So placing children in somebody's care for a limited period of time? That's the first question. And the second one, the adoption as such, not the foster care, the adoption. Doesn't the adoption require a judgment, a decision from a court and the consent of the parents? Thank you very much, Chair.
Exactly. This is happening exactly without the consent. But I advise you to take a look at the item 14 in your dossier. You will find very much of useful information there. Since we are running very, very short of time, I would like to give the floor directly to Jana Tom now.
Well, thank you. In fact, I fully agree with previous speaker, and I think in this case there are several questions that shall be answered on the EU level. Before this meeting, I contacted the Estonian consul in London, and he told me that he came across 3 to 5 cases of removal from families of Estonian kids. And according to his estimates, 3 or 5 cases of removal are justified, but he has serious doubt regarding the rest 2 cases out of 5. And a little remark that some number of cases are not reported to our consul for their foreign permanent residents of Estonia. As a rule, they are Russian citizens who has permission to live in Estonia. But this is UK, and however, Estonian families experience much more problems with social workers in countries like Norway, who is not a member, and for instance in Finland. Estonia has a very small population and only a small portion of its residents in our member states, in other member states. Nevertheless, we can report at least a dozen of very complicated cases annually. We may presume that these figures are much higher for bigger European nations. And therefore, we cannot overlook this problem. We should admit that we do not have enough information about what is going on in the EU in the area of children's custody or removal of children by social services. We do not know for sure what problems are encountered by those Europeans who execute their freedom of movement. And petitions are a valuable source of information, but this is not enough. And I believe that maybe Petty Committee may order special research to address these issues. We still have an opportunity to do that. And one more point. It will be against basic European principles if people are afraid to visit member states where children protection is based on unclear principles. I have a feeling that local authorities in UK may ignore cultural, linguistic and religious diversity of the Union. And therefore, in the interest of better integration, we need common rules of the game at the EU level to avoid violation both of children and of parents' rights. And therefore, the answer that we can do nothing, it is, how to say, it's not constructive. Thank you.
Thank you very much. And now, Madame Zdanoka, the floor is yours.
Thank you. And I am thankful to all previous speakers, my colleagues who are supporting the petition, and of course, especially thankful to Sabine McNeill, who has summarized and gave us so valuable source of information. And what is especially significant is the chapter 3 of her paper, that UK is unique, just unique on out of all 28 EU member states on forced adoption. And we have already examined in the 19th of March the petition from Latvian citizen Laila Bryce, which is still pending and open, and Laila is here also just to prove that unfortunately things are going very badly when contacting, addressing British authorities concerning petitions. And we have just this letter from British authorities out of 10th October 2014 in our files, answering just on Mrs. Massoni's previous chair of our committee, who wrote the letter as of July 2014, and there was an exception on not respect of European Parliament's Petitions Committee, and I think it is the case, while the Councillor of Maxi Martin is writing it's not a non-respect, it's our administrative error, but still what is essential in this answer that there is no answer on substance, because they are writing, we have to obtain the permission of the English court to disclose factual information and evidence to you in order to contradict the assertions made by petitioner. So still court permission and still this clause, which is unique for Britain, which even threat to petitioners to be punished when disclosing their cases before the Petitions Committee. And it will be the case of Lukyanenko, which we'll see further. I am stopping now just saying that I am very thankful to the representative of the Commission, saying she will not repeat this reference to Article 51, which we hear every time the Commission is dealing with a violation of Charter of Fundamental Rights. But I am very happy that we have received these answers of Mr. Timmermans, saying that he will be ready to sit down with our chair of the Petitions Committee to see whether there are problems with Article 51. So I hope very much, Chair, that you will sit down and you will resolve, we will discuss how to resolve this contradiction of this restriction. But my opinion is that if we have in cases, and most of them are like this, of other EU member states citizens living in Britain, it is just a prohibition of freedom of movement, which is in the treaty. So it is EU level, and it's our competence. Thank you.
Thank you. And the last speaker on my list today is Peter Jahr. I give the floor to you, and by that I close the list. We need to move on.
Ja, vielen Dank, Frau Vorsitzende.
Thank you, Madam Chairman. I think listening to colleagues, everyone is, I think, saying the same thing. And there's a great deal of consensus and common ground. I think there was a general feeling of dissatisfaction, and it's been said, of course, that this is not the first time this has arisen. Clearly, where human rights, EU legislation is being infringed, the problem is that you're going to end up slightly chasing your tail. Because the member states, the UK, they've got a kind of closed shop approach to this, saying, no, that's nothing, this is nothing to do with you, dear European Union, this is our business. And we're happy that it's that way. And the official dum in the UK, the official line, is that things are okay as they are. And I would suggest, Madam Chairman, that we take a closer look and we delve more deeply into the subject. In fact, that we organise a hearing so that we can take soundings, see what can be done, what should we do. I don't know. I would not claim to be versed in all of the technicalities of this area. But of course, people do say that politics begins by taking a close look at the real world. I think that we are doing that. If we are not happy with it, then we have to change it. And how do we do that? I think that the hearing, together with our experts in the Legal Affairs Committee, perhaps, I think we'll need their wisdom, given the complexities. We'll need to also proceed on the assumption that anything we do, we've got to. We're going to be in here. We have to hear both sides. No doubt the member states are going to dig in their heels. They're going to want to defend themselves. But I think that, in all fairness, we have to recognise that in child protection, it's not just the UK. In Germany, there have been many petitions. In Denmark, many petitions as well. And the closer you get to the cold face, as it were, down come the curtains, and the member states tend to retrench behind their national borders and claim that this is their business and no one else's. It's come back to here so often. It's been such a recurrent thing. This is a petition which speaks to our immediate bailiwick, but I think that we've got to look around in the Parliament and pool our resources elsewhere. It really does pain me when petitioners come to us and they hope that this is the right place. And I think this does give them some aid and succour, some encouragement. But I think that we're going to need to take practical steps. Thank you.
This is probably an issue that is among the most difficult that we have to handle altogether, because it's about children, it's about our future, it's about human life and human suffering. Probably one of the most difficult issues that we are tackling in this committee, and we need to do it carefully, and we need to do it with our brain cool, but our hearts warm. And this is the tricky part. I think that we should now move on to the next item, and we have with us petitioners, Mr. Eugene Lukanenko-Soifertis. Are you here? Yes. I'm happy. We also have Mrs. Boguslava Glazewska, present, and Ms. Asta Ignatavice. You're here on behalf of your sister. And we will have a statement by video. So I think I will open the floor now to Mr. Lukanenko-Soifertis.
Thank you very much. First of all, I'm much grateful to petition committee members for giving me a chance to talk to you. I'm Dutch national by Russian origin. I'm Jewish. My religion is Judaism. First of all, I want to refer, as a member said, about child protection and about reaction of British authorities. I have in front of me an injunction which says, upon father informing the court that he plans to travel to Brussels, where his petition is to be mentioned on the 11th of November, it's ordered that father be forbidden from disclosing any information or evidence from this case and case number this to any third party. Father be forbidden to information which might lead to his son identification. Father be forbidden from disclosing any information, forbidden from allowing, encouraging, otherwise facilitating of expressing views of my son, including his views about professionals, in this case, about time he spent in the foster care. On my day of departure here, I got a conversation with the solicitor. I'm his single carer. I'm talking to you like to a parent, not like to a member of petition committee. I got a very serious warning. If I name a council, my son might disappear. Name of the council is very well known. It's on your files. MP John Hemming now put a motion in the parliament to check legality of this so-called injunction. Yeah. This injunction doesn't have a date on it. Another copy has a back date, 16th of October. In my presence, judge was advised by local authorities if they could help a judge to draft this injunction. So it means it was ready before Judge Reber stamped it. Okay? That's about best interest of the child. I can't name of this council, I'm afraid, for my child. Every year, 120 children disappear in Kent. It is a gang I'm dealing with, not child protection, not this nice. This is a gang. I'm afraid for my child. I want to apologize. I cannot air the name of this council, but I have a warning that video is being ready. So if my child will be harmed, video will be sent to every petition member with his views. Is it in the best interest of the child to shut his mouth, not to be able to express his view? I will remind, so I have taken all the time. My child was thrown to foster care without any issues, a perfect pupil of a private school, 9 years, 7 months. His friend, white British, came, made a fire at the property. Children left property being he was unharmed. My child was thrown into care. I was arrested, charged, and then justified. Why other child was not arrested? Why his parents were not charged? I plead a case of a clear racial discrimination. That's one thing. On the last hearing, there was a vicious attack against my religion and against my language by a social worker named Palace. She saw my son 30 minutes on 2 occasions, and she maintained that I thrust my religion upon him. Since he is here, be a member of a synagogue which we attend, this is our religion. So, on what right, on the best interest of the child to put this on me? Secondly, we were not allowed to talk Russian. It's our family language. My child is bilingual. So, social worker maintains that I'm forcing this language upon my son. How possible he speaks since he is with me all the time? This is the second one. I put it like a case of a discrimination. A reason why he wanted to be kept into care because I employed Russian nanny who was British national, but they spoke Russian. Is it a crime to talk Russian to my son? Is it a crime to have Russian-speaking nanny? That's what British, basically, in this case, council is for.
Sir, we have many more items on this point. Could you just wind up quite quickly?
I want to tell you that what's going on in my case has nothing to do with the child protection at all. It's not the best interest of the child to be served like that. This is a case of open discrimination. So I just kindly ask you if you could just help me in something, because I'm dealing with a gang, and I gave you also proof of this injunction without date. Another one has a backward date. It was dictated. I'm threatening to be arrested in Gatwick airport when I come back with my son. Is it something which you're not interested? Well, I'm really sorry to take your time. It's a very serious threat. I was told by one of the leading states of the region, when you come back with your child, you might be arrested. I'm his single carer. You'll be detained, your child will go to foster care and disappear. May I kindly ask, is it something which has many other petitioners? Or maybe you can kindly give more closer look on it? I'll leave it up to you. Thank you for your time.
Thank you for your statement. It's an important statement, and we wish that we would have all the time in the world to discuss it with you. We understand that you're suffering and that he is suffering a lot. There are similar cases, not exactly identical to yours, and you will have the opportunity of listening also to the others until we try to come to a conclusion on this particular item. Listen, you do not speak into the micro, and I don't know if...
Medway Council, okay? I know that world know who is persecuting my child. And if one hair will come from his head, all the world will know about it. Sorry,
okay.
I finished.
Please, I know and I understand fully that having suffered so much, you get very upset. And it's understandable. Let's just now move on to the next speaker, who is Ms. Glazewska. I would be happy to give the floor to you.
Thank you. Wielce Szanowna Pani Przewodnicząca.
Thank you, Madam Chairman, ladies and gentlemen. I'm turning to you for help on behalf of defenceless children and intimidated families as a Pole, a resident of Great Britain and a citizen of the European Union. I'd like to remind you that a parent has been arrested in Britain after addressing an EU body. I'm here because I think the issue should be discussed. We should not be gagged. I want to help the tens of thousands of children seized by the British system. I've been fighting for the return of children for 2 years. The system is nothing to do with justice. It's just about winning the case and increasing the number of adoptions. A social worker has tried to force me twice to sign adoption papers. I've been accused of sexually abusing my own children. Yet, when interviewed by the police, my children never said anything that could have led anyone to believe that there was any substance to these allegations. Nonetheless, I am facing prosecution on the basis of guesswork. There are all sorts of assumptions, presumptions made. The social services say that they issue warnings, that they notify. I was never warned. I was never even notified that my children were seized. I found out a couple of days later. The children's father has been blackmailed into agreeing to handing over the children. The children have been deliberately denied their nationality. They can't speak to their mother, their father, their family. I asked for the children to be able to visit the Polish church and Polish Saturday school. These requests have been dismissed. Prisoners have more rights. They are not denied their identity, their family links, their cultural heritage, their religious affiliation. Since in foster care the children are dirty, poorly clothed, hungry, bruised. Nothing is done when I draw attention to this. Social services and the foster family have been responsible for terrible psychological damage by forcing the children into making false declarations, including about the sexual abuse I referred to earlier. My emotional son ran away from school because he wanted to be with me, and yet the authorities say he doesn't want to meet me. The last time I saw him, he said he wanted to come back to live with me. I haven't seen him since because he has obviously been punished for saying something he shouldn't have done. The same has happened with my daughter. The social workers are denying parents contact with children. I haven't seen my children for 7 months. The court has also allowed the father the right to see his children, but the social services are not allowing it. For the past year, social services have been doing everything to block my efforts to have the children return to Poland. I have been insulted and humiliated. 4 months after they were taken away, I was told that my children's clothes smelt of fecal matter. I was accused of putting poison into the children's food. The court has been very selective and tendentious in dealing with evidence, and it has favored the declarations of social services. My independent documents were rejected. I was also denied interpretation at hearings. Documents, including medical documents concerning the children, are kept secret, and I have no access to them. I think what has happened partly because of our origin. Poles suffer political and media persecution, with insults and stereotypes bandied about. There is a lack of understanding for Polish culture, heritage and traditions. Polish families suffer threats, hostility, aggression and discrimination. There has been an increase in racist attacks on Poles, and for no apparent reason, Polish families see their children taken away. In the beginning, I simply gathered evidence, took pictures, consulted organizations there to support me. But I know now that it's not about justice. I know that this is just about blackening people's names and denying the parents the right to defend themselves. I'm accused of all sorts of things, partly by means of words put into the mouths of my children. Public servants should not harm the interests of children and their parents. The system is not under sufficient scrutiny, and there is thus abuse. In fact, it's not the courts that are taking decisions, it's the social services. I appeal to you to look upon this personal tragedy and to help these poor children who are being taken away from their parents and forcibly orphaned. Thank you.
Thank you very much, and thank you for having the courage to share with us your story, which is a heartbreaking story, really. I would like to invite Ms. Asta Ignataviciute to now give us your statement.
I will read on behalf of my sister, Audrona Barkauskina. Lithuanian authorities did not return my personal documents. That's why I cannot come, and I would like to instruct my sister, Asta Ignataviciute, to present my petition number 2546/2013 in the petition committee meeting. My son, Vytis Barkauskas, Lithuanian national, born 2007, January 11, was forcefully, without any court order, kidnapped from the toilet on 23rd September 2013 against the child's expressed will to live with mother. There was no interpreter, no ambulance invited when we asked to provide it. Child stiffling shouted in English, "I want to live with mother, let me go, mama." One of social workers, Sally Ann Van Minnen, was not registered under Professions Council. People in police uniforms threatened mother and her son that they will detain her because child is in queue for school. Mother got schools for her son on 23rd of September 2013, short distance from home. There were 614 children in Brand Council who did not get primary school places in 2013 due to the lack of schools in Brand. There was planned attack against the small son and his loving family. On the 4th minute, 2 seconds, PC Price says to his colleagues, "We try attack, we try attack." Mother and grandmother were assaulted and kidnapped for 24 hours to Wembley police station in handcuffs. Mother and grandmother got fake charges that the two ostensibly assaulted 6 strong officers. I never signed any papers. Every day I asked to return my son to me. There was no reason to kidnap him. By valid Lithuanian court judgments, son Vytis always lived with mother. Mother protected her son from father's abuse whilst in Lithuania. On the 26th of September, after 3 days of my son's kidnapping, my son Vytis Barkauskas was taken to UK care. Mother was not announced about the court hearing. There was written wrong name and surname of mother on the court order. Mother was told that there is no any hearing when she contacted Willesden Magistrates Court. Child said to UK social services that his father abuses him. Mother and child and all family are psychiatrically healthy. However, since the first hearings in court after the performed son's Vytis kidnapping, local authorities humiliated the responsible caring mother, threatened her with mental hospitals and jails. Unfortunately, the same authorities return the child to father who is physical and sexual abuser. My son doesn't get the best treatment for his heart murmurs, blindness, selective eating disorder when he is in biological father's care. My son's health is destroyed. Lithuanian social services provided faked, falsified documents to UK authorities. These documents were announced unmotivated by valid Lithuanian court judgments. Child's father, Lithuanian advocate Spaičienė, and Lithuanian Adoption Service Director are friends. That's why the child was given by UK authorities to abuser after 1 year in foster care. Despite the fact the child and mother was asking for protection in Britain due to abuse by father and Lithuanian authorities. Lithuanian authorities opened the falsified criminal cases for Vytis loving family because we announced about child's experience horrific abuse from father. The medical records, 2 surgical operations, psychological records, forensic records, child's testimony to Lithuanian police and to UK authorities proves that son experienced horrific abuse by father. UK authorities hide the child's father's criminal records and his father's medical records. Lithuanian psychologists detected father being psychopath. My son is not saved with abuser father Almantas Barkauskas. He asks everyone to save him from Almantas Barkauskas. He asks him to save from his abuse, but nobody listens to him. My son Vytis told he wants to be happy with mother. No one sees child suffering. UK authorities gave the child against the child's wishes and feelings to his abuser father and deported the child to Lithuania. There was breached my son's right to life, to safety, to happiness, giving him to abuser father. Child's health totally reduced when he was taken from loving mother's care and given for abuser. Gagging order was made by UK High Court to forbid mother Audronė Barkauskienė to speak about her tragedy that the child is given to his abuser father against the child's and mother's wishes. The authorities of Great Britain have violated the prohibition of direct discrimination by language as well as indirect discrimination by ethnic origin and nationality, all forbidden by Article 10 of the Charter.
Excuse me for interrupting. I understand that your statement is quite long, but could you please come just to a conclusion?
Okay. I want to say that many articles were breached, many child's rights were breached, and genocide was performed to my whole family. And I want to say that the child was snatched from a loving, protecting family to alcohol-addicted foster care, while in foster care in UK, it is confirmed by UK authorities' documents and then returned to the abuser biological father. Thank you.
Thank you very much. And it's really painful for me to cut you short, all of you, because your statements are emotional and important, but we need to proceed. And I'm now happy to give the floor back to the Commission to reply to what we have just heard.
Yes, thank you very much. I have listened very carefully to the petitioners, and I would like to thank you all for taking the trouble coming to Brussels and sharing with us your painful experience. I'm really sorry to hear about your terrible difficulties, and I understand that this must be an extremely distressing time for you all. Here again, as I said to Mrs. McNeil, I will spare you the usual discourse on lack of competence. What I would like to underline, however, and I think this could be useful for some of the petitions, not all of them, a decision by social services can and should be contested if deemed unfair. The UK courts are there to hear these cases and overrule a decision taken by government or local authorities if they're convinced that the decision was not the right one for the child and for his or her parents. You have the right to exercise these domestic remedies, and the Citizens Advice Bureau in the UK can help you there, and we can give you the references. As expressed by the UK authorities in the letter I mentioned earlier and which was distributed today, under the Children's Act, which provides for the framework for English protection system, here I quote again, the local authority must first seek to enable a child to return to his or her family. If that is not possible, then they must seek to place the child with a member of the child's wider family before considering a stranger. This is because it's often the best for the children to live with someone they know and allow for continue of their lives reflecting their racial, linguistic and cultural background. We will, of course, pursue our very close contacts with the British authorities on these issues, and I understand that there's maybe a possibility for this committee to contemplate a study visit to the UK to get the full picture. What I would also like to add, and I touched upon this earlier, is that following the meeting in the March Petitions Committee, we've launched a public consultation on the child protection systems in the Member States, and the Fundamental Rights Agency, the so-called FRA, has mapped structures and initiatives in place in the Member States to protect the best interest of the child in situations which also cover adoptions and custody. All these results will be published, of course, and we will, based on this work, come up with guidelines early next year. In these guidelines, we would like to set out the principle for a rights-based approach that can usefully guide child protection systems and help to ensure a common understanding of how the rights of the child can be best protected and promoted. I think we need to go beyond existing structures and processes and make sure that they work and deliver in the best interest of the children concerned. Expertise of those who work in the child's best interest has to be developed, and the Commission has very recently launched a call offering funding for the capacity building of staff in child protection systems. The prime consideration is and remains, and I cannot underline this enough, the best interest of the child. And a rights-based approach will, for example, encompass, and there I turn also to Mr. Lukyanenko, the importance of the child's right to be heard in decisions that impact on his or her lives. This is central to custody decisions discussed today, I think. Thank you.
I have a very short speaking list. I only have Mr. Saki on the list, and I'm happy to give the floor to you.
Thank you very much, Madam Chairperson. I try to be very, very short. Firstly, I see that we have now on the table only 1, 2 or 3 problems. There are a lot of problems. I'm afraid that's a problem of the system. So my recommendation to you and to the Commission is to inform maybe Mr. Timmermans and the European Commission on this problem, that we see here a serious problem, firstly. Secondly, it would be good maybe to ask the European Ombudsman if they have also some similar problems or informations, and to invite them maybe to the discussions how to solve this problem. And thirdly, maybe to ask the Commission to prepare an analysis what will be maybe our common steps, systematical steps, how to solve this problem, including maybe establishing of a new European legislation or a new system for the protection of rights of child, because I see that if we will continue here in such a form of the discussion, we will be got in the future also a lot of other concrete issues. So it will be I think necessary to solve this problem systematically. Thank you very much.
Thank you very much. And how on earth am I going to conclude on this now? I'll do the following. First of all, we keep the petitions open. This is necessary. We need to look into depth into the issues and the subject. We need to mandate our Secretariat to work together with legislative committees on this, to actually see what we have at stake. I happen to know that the Jury and the Libe Committee have requested a study on cross-border parental child abduction. And this will be presented in Jury and Libe quite soon, I believe. And what we could do is to mandate the Secretariat to reach out to the two legislative committees and ask them to kindly invite us to come, based on the experiences that we have had today and based on what we have heard, the statements that we have heard, and also the Commission's conclusion and probably the guidelines and the Fundamental Rights Agency's mapping will be made public by then. So this is what I would propose. We have also already decided today to invite the Vice Chair, Mr. Timmermans, to our committee, and this would be an excellent topic to put on the agenda for when he comes to our committee. And this is the way forward, I believe, that we could do. And I now see that we should also reply to the letter. Of course, it's not acceptable that any European citizen feel that when exercising the right to petition you are put under threat. This is completely unacceptable and must never, never, ever happen. So we could write a letter to the UK authorities on that, and then move forward as proposed. And now, Mrs. Zdanoka, the floor is yours.
Yeah, I'm very thankful, and it was my request to write a letter concerning Lukyanenko. But also there was proposal from some members, I don't know, on our possibilities on fact-finding mission, what to Britain, what do you think about it?
You know, that's for the coordinators to decide. We have already decided that we have a huge backlog and we must be very restrictive. I do believe that if we are clever in this committee and work with the legislative committees closely together, this is the most fruitful way forward in substance addressing the issue. And if we can get Mr. Timmermans to come here quite quickly, we have items to discuss with him, and this would really be a top priority. He is, after all, Vice President of the Commission. This has to be addressed, and it must come to an end, what is going on in Europe. As one of the colleagues stated, we have heard such stories in other countries, in third countries, but it should never, ever happen in Europe. That's for sure. So can we agree on the proposal? Mrs. Mitzi?
Grazie. Thank you. Each and every complaint that we heard today is important. However, when we are speaking of children, we just cannot wait for things to happen. We cannot wait to have an appointment with a commissioner. I'd like to therefore suggest that even if every problem that we are confronted with is important, and we also recognize the very difficult work that this committee manages to achieve, problems like the ones we've had today, which deal with children, these cannot wait. Each and every day is an extra day of suffering, be it the children, the parents, or other members of the family. Therefore, I'd like to suggest that maybe we can create a subcommittee which would deal solely with children's issues that are really important and that simply cannot wait. I don't know if such a suggestion is a valid one. Maybe it has already been proposed, but it would mean that these problems are being addressed every single day. Children have nothing to do with noise or environment, even though everything is important, but children simply cannot wait.
As you have just pointed out, every day that as children is been taken away or detained is a lost day, and for a child 1 day is like a month for a grown-up. So we have already today taken a decision in this committee, and I'm proud of it. We have said that we are to address issues concerning children on a fast track. This has been completely agreed. So we are already on track on that, which is very, very good. Now I give the floor to you, Mr. Wieland.
Thank you very much, Madam Chairman. When I was a lawyer, and actively a lawyer, I dealt with family law. And it's not just that people argue or have a dispute, but obviously there are children there, and the idea is to try and come to some kind of compromise if there's a problem between the parents. But we have to be careful about how we approach all of this. When we're dealing with children, this falls within the competence of the member states. So we only have 2 or 3 possibilities. Either there are a couple of areas where European legislation has been created, or we can say that somebody is being discriminated under a national system because their nationality is different to that of the member state in which the affair is taking place. So this is all to do with the rights of the European citizen. And then thirdly, more generally, the provisions of the Charter of Fundamental Rights are being violated, and we do have possibilities there. And I think it's probably going to be better to have some kind of fast-track chamber at the Court of Human Rights in Strasbourg if we're dealing with children, because new facts come into play and we're dealing with the welfare of the child. We've got custody, we've got all sorts of rules on this, but of course all of these rules are in the competence of the member states. There is European legislation. As you said, this is all heartbreaking, and we have a lot of empathy for what we have heard. But unfortunately, as I said, this falls under the competence of the member states, so we shouldn't rush this. We shouldn't sort of rush forward on this. Mr. Timmermans obviously would be able to give an idea of what possibly could be done. These may seem that, even though it sounds awful, these are normal cases in certain member states. Not all children or not all parents necessarily agree with the decision of a court, but so we shouldn't forget that either. Thank you.
Okay, now I see no more hands in the air. Let me then try again to repeat what has been said, that we from the Secretariat side reach out to other competent committees to find out where the European Parliament is at this point on Brussels II, on various legislative proposals, and then that we move on, inviting Mr. Timmermans. We need to discuss this with him. We also reach out to Juri and Libe that has already requested a study on cross-border parental child abduction, and they will present it in a hearing, and we invite ourselves to the hearing, and this would be the way forward, together with the letter to the to the UK authorities concerning the right to petition, and that there must never ever be threats connected to exercising that right. I take your silence as consent. Okay, excellent. It's been approved. Let's then move on to the next item, which is Kyrie Yiannopoulos Konstantinos. Είσαστε μέσα στο δωμάτιο μας?
Are you in the room? Could you just wave, please? Welcome, Mr. Yiannopoulos. You have the floor.
This petition is about custody rights, breach of custody rights by the national authorities of 2 member states. My sons, they were living in Cyprus, and in 2010 they were abducted by their mother with, as I explain later, the support of the national authorities of the UK. And this long-last retention in a third state in the Gulf, United Arab Emirates, could not occur without the help of the national authorities of Cyprus. The direct contact between myself and the children have been interrupted since then. The children, they have Greek nationality. According to the UK laws, their domicile is in Greece. Their mother is Hungarian, but the mother holds a British passport, and thereafter the children could get a British passport because of the connection of the mother with Britain. As I said before, this abduction could not have taken place if they were not due to the national authorities of the UK to provide the mother with passports, although they knew her intention, they knew her plan, they knew that they were going custody proceeding in Greece. They knew that Greece has exclusive international jurisdiction to decide on that. And nevertheless, some people behind closed doors in the Foreign Commonwealth Office in London, they decided to take the case from the Greek courts to judge it themselves, without, of course, judges, without lawyers, without wasting time, without witnesses. And they decided who of the two parents will take the custody, where the children are going to live, and how they will grow up. They were aware that they may not be able to see them again. I have to say here that my stranger wife, she took some legal action in the UAE, which I cannot visit. That's why it has been interrupted, the direct contact. They don't come to me, and I cannot go to them. They have nothing relation with the UAE, simply she works there, but that's the strange facts. The UK authorities, they recognize later their mistake. I asked them to withdraw the passport, because in that way the UAE will force them to leave the country. And the reply was that although we give her passports, we told her to check the law before she takes the children out of the country. So this is like a joke. It's like you give a gun to the child and say, don't bring it in the school and shoot your friends. And if he does so, you say, it's not my fault, I told him to not do it. As far as regards the Cyprus authorities, we didn't have the report from the Commission, I have to say here, but again there, under strange circumstances, was suspended the international arrest warrant that was issued against the mother. That's because the place where the crime, if you want to call it like this, took place is in Cyprus, and only then they can activate Eurojust and they can issue international arrest warrant. When that was notified to the mother, within 24 hours this was suspended, and then I didn't manage to bring it back. Now it sounds strange to you, but this is a normal procedure. This is the fastest way. This happens very often, almost every month in Cyprus, because there are a lot of international couples. This is the way to bring the children back and nothing else. Now I have to say a few things about the case. The UAE is a not signatory country of the Hague Convention, so no civil proceedings for the return of the children can take place. This case is dealt under EU laws, despite the fact that the Commission, in the report that sent to the members in the summer of 2014, has hid that. The Commission themselves recognized that when they examined my complaint against Cyprus, and in my response of 29 of September, where I sent to the Secretariat, I included reports and letters from the Commission where I admit that. The family court in Greece has decided that they have international exclusive jurisdiction. In the UK, the Ministry of Justice has recognized that this case is dealt under regulation. There is a consultation outcome on the balance of competences between the EU and the UK laws with regard to the civil judicial cooperation, especially on family matters. This is on the internet. There are some evidence there, and my case is individual to evidence. If you scroll down the menu, you can see that. And the letter that I sent to them is almost the same, the letter that I sent to this petition committee, and with a difference of 1 week. So, despite the fact that the Ministry of Justice recognized this is dealt under regulation, the Commission takes the position that issuing passport is not part of EU law. The question is not the passport itself. The question is that as a father, as a custody rights holder until now, I have the right to decide on the place of residence of the children. This is Article 2.9 of the Regulation 2201 of 2003. And the British authorities, by providing the mother with the travel documents, effectively they authorize her to take the children out of a member state and to bring to a third country far away from where the EU jurisdiction can reach. I think if you were talking before about the best interest of the children, there is actually very recently published a long paper by the Vice President of the European Court of Justice, and in one decision, case C400 of 2010, para 60, the court decided it is apparent from the recital 13 of the regulation that recognizes the fundamental rights of the child. Accordingly, the provisions of that regulation cannot be interpreted in such a way that they disregard the fundamental right of the child, the respect for which undeniably merges into the best interest of the child. So the British authorities, and I say also the Cyprus authorities play a part, they decide themselves that the best interest of the child is not to meet with the father. Thank you, Chair. That's all I had to say.
Thank you for being so precise, and thank you also for providing the slides. That makes it more easy to follow your reasoning behind your suffering. I give the floor right to the Commission, and I believe that we have Claire Agnès Marnier in the room.
Merci, Madame la Présidente.
Thank you, Madam Chairman. Thank you for giving me the floor. The situation of the petitioner is particularly painful and upsetting. I think all of you will have realized that. The Commission has examined all the documents that the petitioner sent in very carefully, in great detail, and we have also met the petitioner on 2 separate occasions and listened to what he has to say about the situation. And we realize, of course, that he is suffering enormously because he is unable to see his children. We as the Commission have focused on those aspects and elements. Obviously, in the UK, we've taken a look at the actions of the Cypriot authorities. Our conclusion is that, having taken a look at all these various elements, we have not been able to determine any failing vis-à-vis EU law on the part of those 2 member states. Obviously, we have also given some thought to possible action in such a way that we can help the petitioner come back in touch, have contact with his children. The problem that we face, though, or that he faces, is that the children are currently in a country which is a third country, a non-member state of the European Union, i.e. the United Arab Emirates. And here the Commission has no powers vis-à-vis a non-member state of the European Union in this kind of situation. In more general terms, the European Union is doing everything to strengthen family cooperation and integration together with third countries on the basis of multinational instruments. There's the Hague Convention of 1980 on the civil aspects of the international abduction of children. And there are certain specific projects and actions which are being considered, but the United Arab Emirates do not form party to these actions. Once again today, we've heard the petitioner stress the fact that the Greek authorities, either the authorities of a member state, were called upon to determine parental responsibility in the case of the children. And today we would just like to point out to the committee and to the petitioner that if this were to enable us to improve the situation, then that is a path that perhaps the petitioner could follow. Perhaps the petitioner could request some form of diplomatic assistance with a view to unblocking the situation in more specific terms so that he can actually meet his children again. Thank you very much.
Je vous remercie. And now,
thank you very much.
Colleagues to intervene on this subject. I have Eleonora Evi. The floor is yours.
Sì, grazie.
Thank you very much, Madam Chairman. The cases we've dealt with this afternoon have all been very distressing and very difficult. And I think that what has emerged after all of this is the need to plug the gaps which clearly exist, to fill the gaps. There may not be much that the European Union can do, but that is not sufficient. That cannot be the whole answer, because there are situations which arise where people simply, as it were, fall through the gaps. And we're talking here about the rights of parents and the rights of children. Sometimes they seem to be lost from sight. Now, this is, I must say, a new area for me. And I very much hope that we're able to delve deeper by means of hearings, which is one avenue that we have, and also by the European Parliament has, in the past, set up special committees of inquiry in order to investigate particular areas. The Ombudsman certainly has powers when it comes to the abduction of minors. But of course that's one person, that's an institution, but it's only a person at the end of the day. And even they are not going to be able to get to the bottom of things. I think they would not necessarily have the legal resources, or for that matter the psychological expertise. Now, on the question of a public consultation on Brussels II, that I think that there is ample reason, for ample cause, for us to keep this petition open as we look at that, what that public consultation may bring. Another thing which has emerged with clarity is that often the regulations are not being respected, not being implemented, and of course that is something else which we need to factor into our equation. Thank you.
And now, please take the floor, Mr. Wieland.
Ja, vielen Dank, Frau Vorsitzende.
Thank you very much, Madam Chairman. Well, first of all, it must be said that there are cases which are very difficult for us to get a handle on and to deal with or to address. Can I just put in a word to try to help in connection with the Commission and the division of Brussels II? I can imagine that when it comes to preventing abuse, we can send a recommendation to member states and get undertakings from them, so that where cases arise, there is a need for two signatures for a passport to be issued. And if one parent refuses to give consent, then that parent can only be replaced by a judge or by a court. It could well be that one parent is very sick and they are unable to sign. But I think in that case they should be replaced by a court or by a judge. Now, secondly, with child abductions, perhaps Brussels II can help whereby the member states agree that that the international order is issued more quickly. There are cases where there are not agreements which cover that, such as the United Arab Emirates. I'm not talking about that particular case, but there are countries where countries have not signed up to agreements and where you cannot assume that you're going to live a long, peaceful, safe, secure life. And if they want to get back to, as it were, the civilized world, then it may be necessary for there to be an international arrest warrant issued. I think that this is a case where we can refer the petitioner to the work of Mrs. McGuinness. She sits in the Bureau of the Parliament, and she has a responsibility for child abductions. And perhaps by means of soft diplomacy at that level, there may be things which can be done. And, Madam Chairman, after the meeting, perhaps not on the record, I would like to make a suggestion as to provide some practical assistance. Thank you.
Thank you very much, and that will be very useful.
Can I say something?
Excuse me, I will just give the floor to one more colleague, okay, and then back to you, as the normal procedure would be. Is that okay? Okay, so then, Mrs. Kuneva, the floor is yours.
Thank you very much. Can I make a proposal with regard to the petition by Mr. Yiannopoulos and suggest that this petition be left open, be kept open, and that we await the outcome or the findings of the hearing which we intend to conduct. Thank you.
Excellent. And by that, I'm happy to give the floor back to you, Mr. Yiannopoulos.
Thank you. First of all, the international and European arrest warrant can be executed in third stage with the help of Eurojust. Eurojust, on the mandate that has from the Council in 2009, in the mandate, they can communicate with third stage to execute European arrest warrants. The Child Protection Unit at Eurojust can be contacted. They cannot open investigation until there is requested by member state. The Greek prosecutors at a very high level, they cannot open a case because the locus delicti is not in Greece. And Cyprus refused to reinstate the international arrest warrant that was issued in 2011 and was suspended in a scandalous way. Further, with the passports, in the UK you only need the signature of one parent. I cannot go to a Greek court and ask to withdraw the passport issued by another member state. I cannot go to the UK because the children are not in the UK. So there is no civil proceedings I can take to suspend the passports. Only this Parliament can ask the UK authorities to suspend the passports, to withdraw, and then the UE will force the children to leave the country because they cannot stay there without a passport. As far as concerns the response from the Commission, it's true we met 2 times. The second petition was my petition was against Cyprus for breaching the EU laws, their court decision when I apply for protective urgent measures. This complaint is about the other authorities which they don't recognize that this case is dealt under the regulation. They don't accept that Greece has exclusive international jurisdiction, and they don't accept the definition of abduction or wrongful removal which gives the regulation. This is about this petition.
Thank you very much. And now we need to just wrap up and keep going because we still have many, many more open issues. A possible way forward on this would be to send letters to respectively the Cypriot and the UK authorities on the arrest warrant, on the adoption of the Brussels II regulation and the situation, and this goes, as well as the previous item, back to the Secretariat to further investigate on how to proceed, to get in conjunction with what we just concluded on the hearings, on the Juri Libe and so on and so forth. We need to really look into this in depth. And by all means, the petition is kept open. Is this the way forward? Excellent. Now, is the next speaker in the room Mr. Klaus Zinser? You're here. And, you know, I'm happy to give the floor to you, but please try to be as precise as you can since we are running short of time.
It's petition 1229, 2013, Klaus Zinser. This petition will be jointly presented within 5 minutes. Good afternoon. First, I would like to quote the UN Convention on the Rights of the Child. Article 9, Part 3. States parties shall respect the right of the child who is separated from one or both parents to maintain personal relations and direct contact with both parents on a regular basis, except it is contrary to the child's best interest. Article 10, Part 2. A child whose parents reside in different states shall have the right to maintain on a regular basis, save in exceptional circumstances, personal relations and direct contacts with both parents. Okay. Now I wish to discuss exequatur. I want to give 3 documents to the petition chair and to the European Commission. Document number 1, a Maltese court document registered under Brussels 2A, 2201-2003 in the UK family courts, which means let it be executed from March 2012. Document number 2, I applied on the 1st May 2012 for a warning notice to be attached to the Brussels 2A recognized contact order. This matter was listed for a hearing on 6 June 2012 and led to an administrative process in the courts where several court hearings took place and the result being no contact. During one of these court hearings in front of Mr. Justice Mostin, in response to my question about implementing the Brussels 2A order, his response was, "It is up to you to organize it." Later I sent a notice to the respondent via her solicitor that I was coming to UK to implement a court order for contact with the help of a UK court-registered independent social worker, name and CV supplied. Whilst I was flying to the UK to meet the independent social worker, the mother's taxpayer-funded legal team asked the High Court legal team in the UK to have my Brussels 2A court order removed. Document number 3. On 24 April 2013, I received a UK High Court ex parte decision saying the father shall make no attempt to collect his child. This order was made without any evidence from the father or any allegations being made against either party. The UK taxpayer has paid approximately £180,000 to the mother's legal team, leading to a total reversal of the contact order. The father was litigant in person throughout these proceedings due to having exhausted his funds and did not receive any legal aid. I request the EU Ombudsman, Emily O'Reilly, to review both of my requests to the EU Commission in 2010 and in 2013. And also I would like to ask, has the EU Commission ever done an investigation into UK non-compliance with international binding orders which were made in the best interest of the children? As a result, I have not had direct contact with my child since he was brought to UK in 2009. Now, Vincent.
Thank you. Mr. Zinser has demonstrated to the UK family courts its refusal to comply with internationally binding High Court orders. I am Vincent McGovern, Chair of the Central and North London branches of Families Need Fathers. I have had 4 Ombudsman's investigations with findings in my favour, 2 parliamentary against all of the children's services in the London Borough of Brent and the court-appointed CAFCA service. And a good example of systemic failing at local and national level is the MARIC process, Multiple Agency Risk Assessment Conference, whereby, I have this under freedom of information, half of all parents of children denied access to this service because of their gender. This obviously means that a large proportion of children's services in the UK are ideologically and financially incentivised
backdoor social engineering to determine that the father quite often, even if he's a primary carer, would be rapidly removed ex parte without seeing the evidence from looking after his children. By the time he deals with that evidence to lengthy court proceedings, the contact is quite often damaged or destroyed beyond repair. Karen Woodall, a director of the Family Separating Clinic, part of Europe Limited, in support of me being here, says, the UK appears to be following a path of empowering children to make their own decisions about whether to have a relationship with a parent after separation. The Children's Commissioner for England has endorsed proposals that children are best placed to make these decisions, and CAFCAS, the court body charged with working with separated families in England and Wales, has developed practices which uphold decisions being made by children as young as 8. I have documentary evidence of a 3-year-old child being regularly cross-examined by a social worker in Brent as to his opinion on a court order. This is a problem which appears unique to the UK within Europe and which is at the root of the high levels of intergenerational family breakdown, the high levels of fatherlessness and the problems associated with it, such as teenage pregnancy, drug use, jailing behaviour, so on and so forth. As such, it is a concern of the European Parliament because the needs of children from separated families in the UK are being ignored at an institutional level, at local, national and international level in the UK, which is leading to systemic failings in supporting positive outcomes for these children. I ask this Commission to organise a fact-finding investigation into systemic failings in UK family courts at local, national and international level. Thank you.
Thank you very much. I would like to give the floor to the Commission present. I believe it's Joanna Sterdinska.
Thank you, Chair. I would also like to thank for giving me the floor and the opportunity to comment. And if you allow me, I would like both to comment on the petitioner's complaint, but also more generally on the revision of Brussels II regulation, an issue that comes in the discussions throughout today's meeting. Now, speaking about the petition at hand, it seems to us that the petitioner raises principally two issues. One is the non-enforcement of the Maltese order from 2011, and secondly, the issue that comes also from the documents submitted so far is also the issue of the jurisdiction of the UK courts to decide on the matters relating to parental responsibility over petitioner's child. We had this petition discussed at the last meeting, and we had a chance, also thanks to the letter sent directly to the Commission, to reassess and look again at the documents submitted so far to us. And from the documentation we have, it appears that indeed the Maltese order, which has been registered in the UK, by the decision of the High Court Justice, the court asked the petitioner to make an appropriate application for the enforcement. And we also read from the following judgment that in the following judgment, on the request of the CAFCAS, which is the social authority in the UK, the enforcement was suspended, and the court also stated that the father had not issued any application with regard to how he would like to enforce the order. Secondly, the issue of the jurisdiction, which comes also from the documentation submitted by the petitioner, we looked also again in line with the provisions as said in the Brussels IIa regulation. The petitioner explained that he didn't want, and we can understand this, to put his child on the in an additional stressful situation, and did not apply for the return of his. It did not apply for his return. So, after more than a year, the English courts took over the jurisdiction on the substance, and they have restarted the proceedings concerning the custody and access rights. having regard to what I have just said, we could not identify so far the infringement of the EU law. And in our opinion, in the situation where the English courts have now the responsibility for deciding on the substance of the matters, on access rights, we insisting now on the enforcement of the Maltese order, whereas I explained now the decision is in the hands of the English court, probably does not help the petitioner in establishing immediately the relationship between him and his son. And we also believe that the close collaboration with the court, with the local social authorities, might bring some positive effects. And of course, and this is the advice we are giving also to the petitioner, he has all the rights to use all national remedies in case he's not satisfied with the decision issued so far. I would also like to mention that, as some of you might remember from the last meeting, we were informing already in March that the Commission will undertake a review of the operation of the Brussels IIa regulation, which is the main instrument in the area of family law. Let me just briefly inform you where are we standing with this review. As a first step in the review process, we have adopted an application report. This was in April this year. This report covers all the matters in the scope of the regulation, matrimonial matters, but also, of course, parental responsibility matters, including the procedure for the return of the child. As regarding enforcement, which is also relevant to the petitioner's complaint, the Commission highlighted in this report that in practice hurdles remain in connection with the actual enforcement of the orders. And we also pointed out to the fact that while as enforcement as such is subject to the law of the member state of enforcement, the means of enforcement, they differ from one member state to another. And we have also concluded that this may lead, and we see this from the number of complaints, to the situation where parents simply face problems at this final stage, and probably the most important one, of having the order enforced. Let me also say that in order to explore more comprehensively the matters identified already as a first in the report, the Commission carried out a public consultation during the summer. We are currently looking at the contributions received. There are some 200 contributions. We are very pleased with the number and also with all the responses, not only from the professionals, but also from the parents informing us about practicalities, so to say, so the problems with the application of the regulation from their perspective. So we are now also undertaking a further policy evaluation of these existing rules and the impact on citizens. And we aim to present a proposal for a revision of the regulation in the course of 2015. And I can say already today that most probably the issues addressed in the petition will be also covered in the amendment of the regulation. Thank you.
Okay. That is very good to know. Thank you for having informed us on this very important matter. Really. Now I open the floor for discussions, and I only have one. And I would like to actually close the list after Mr. Wieland has intervened, because we have a very big issue to solve before the end of this meeting. Mr. Wieland, the floor is yours.
Ja, und ich habe zunächst eine Frage.
Thank you. First of all, I have a question for the Commission representative. Last time round, I asked the question about indirect contacts in this dossier with the member state concerned, whether it had been possible to sound them out on certain issues. Has the Commission done that? And has the Commission taken a position on these issues? Thank you.
I think that can be answered quite quickly. I give the floor back to the Commission.
Thank you. In the framework of the preparation of the application report as well as the evaluation study, we have collected 28 reports from each and every member state. This now all will be the information from all this will, so to say, flow into the preparation of the overall study. So also the information in particular, not only on the UK, but also on enforcement issues will be covered in the impact assessment study. Thank you.
Excellent. So what we do is exactly...
I have not finished. It was a question from the beginning. Before I begin. Also, wenn ich das feststellen darf,
Well, thank you. Well, I take that as that's a no. In other words, you have not done that. Contact with the member state in this particular case. You'll remember that when it was the Jugendamt, there was someone from the ministry from Germany who took a position, who commented on every case. And it does seem it's not really sufficient to simply express sympathy to the petitioner. In this, for me, that's really not good enough. Now, the petitioner has given us the documentation, and it's perfectly clear on the basis of that evidence and from the presentation today that it's unsatisfactory, that there was no pushing the exequatur with regard to the UK. After a year, the child can be deemed to be a resident in the UK, giving jurisdiction to the British courts. And the court itself, the British court itself, contributed to that year elapsing and nothing being undertaken in the course of that. And then thirdly, the petitioner at the last meeting demonstrated that in thousands of cases, only 53 cases were enforced in the cases where orders were enforced in the UK. Now, I'm afraid that Brussels 2, A and B, they can simply be binned if something is adopted where the member states have signed up to the provisions, and then the member state allows rules in the national courts to undermine and circumvent the terms of Brussels 2. Then it's not worth the paper, and that we must guard against adding any legislation of that kind if it's not going to be enforced. Now, where there is Brussels 2 is applicable EU law, and I'm looking to the Commission and asking them to make sure that they ensure that it's honoured and observed and applied. Now, I have heard reports that not all of the opinions in the platform were actually acknowledged and received. And I think that this has to do with administrative provisions. When someone complains about administration, then it's not something which Mrs. O'Reilly, the Ombudsman, can turn down simply or can dismiss because something is pending. Now, I think it's quite right for the Ombudsman to look into this, but I would be very grateful if you could pass this on to Mrs. O'Reilly. Now, finally, in conclusion, when you consider that the mother of the child received 4 or 5 digit amounts of money for legal assistance, whereas the petitioner has used his own resources and had to go to associations and has not received any assent from anyone, then I'm wondering whether the principle of a fair trial, has not got lost somewhere along the way. I think we should keep this petition open, and I hope that from the Commission that they'll show more involvement, more dedication, even if it's a big member state, and even if the petitioner comes from a smaller country. Thank you very much.
Mr. Wieland is pointing out very important substance matters that we should take into consideration while dealing with this. Would you, by one or two sentences, just wrap this up so that we can move on? I give the floor back to you, just very, very briefly.
At the end, what we can say is the Commission should look very detailed on the foundation of this international consultation. I have serious questions, and if you look on freedom of information requests, you will get to know why. Coming to UK, very simple answer is enforcement in UK is not possible at any level.
Thank you very much for your very prompt reply. What we can do is to actually, together with the other issues that we have handled today, put it in a wider scope, wider framework, and work on this together with the Secretariat and the competent committees and in dialogue with the Commission. I do believe that now when Brussels II is under revision, we can actually enhance our cooperation between the two European institutions on this to make sure that at the end what we'll do. I will also try to see Mrs. McGuinness on this, if it's the will of, since she is the Vice President responsible for this kind of affairs about children, it would be appropriate that we meet and discuss this with her, as proposed by Mr. Wieland. This is the only way that I can think of now, but we'll definitely keep the petition open and try to look into every possibilities to come to grips with it. Can we now move on?
Nur ganz kurz, kann ich es als vereinbart?
Thank you very much. Can we take it then that, given the fact that new arguments have been put onto the table, can we take it that the Commission is going to take this up with the member state concerned? We need to have some kind of follow-up minuted.
I take that as granted. We are going to invite Mr. Timmermans to come here. These are really important questions for European citizens, European children, parents, families, and we need to take it very seriously and try to find out whether there might be even loopholes in European legislation. And if so, we need to address that. So Mr. Timmermans is responsible for better regulation, better legislation, and he needs to look into this.
Yes, Mrs. Chairman, but my point is that the previous petitions I pointed out that we can hardly come to European law and to real to admissibility. The only way is the general human rights. But this, we have concrete European law, and I want to have an answer from the Commission by the responsible unit, not only in general by Mr. Timmermans. I want the Commission now to write to the United Kingdom and ask questions we have concretely and give a report after getting the answer.
This is a very, very concrete way forward, and we'll definitely do that. We'll work together with the Commission on it and see whatever can be done must be done. I take that is so certain that we should not even have to address it. Of course the Commission have to come back. And as they have also stated, there has been an interruption with the new Commission, but now when they are put in place, they need to deliver. Full stop. Can I now move on? Thank you very much. And now the subject is completely different. It's about European schools, and we have 5 different petitions, and we also have the honor to welcome Kari Kivinen, who is the Secretary General of European Schools. Where are you? Very welcome. And we have with us the petitioners, Mr. Ryan, Mr. Per Moles, Sarah Barbier-Cognier, Mr. Manuel Altemir Mergelina, and Mr. I told the same name twice. Could we look at these petitions together, and maybe the Commission can now try to merge your answers so that we, at the end of the session, can have your response to all of them together, just to make sure that we can finish by 6:30 at the latest. Now I give the floor to Paul Ryan.
Thank you. Ladies and gentlemen, elected representatives of the Parliament, I'm grateful for this opportunity to give you evidence today in support of the petition. The petition calls for an independent review into the European school system and its arcane legal basis, and to provide redress for those children impacted by its failures in back 2012. So why does this matter? Well, many of you and your colleagues in the European institutions, you entrust your children's education to the European schools. I entrusted mine, although I should point out that for many years I was a fee-paying parent. 30,000 pupils attend the European schools. I'm a firm believer that the European schools should be a great asset to the European project. It has been in the past and it can be in the future. But I'm here to seek to ensure that it's able to thrive and not be bogged down by its arcane legal basis, which means that there is a lack of effective oversight. With no oversight, the European school system is failing and it lurches from one crisis to another, harming children. The problem: the European schools were established by an intergovernmental treaty in 1957, and they operate under a legal instrument outside of all the European treaties and all European law. Yes, it's not subject to European law whatsoever. Yet the European school system largely only serves those children whose parents work in the institutions. Why should it fall outside of European law? It's an anachronism of history, perhaps, but one, you, the Parliament, you asked it to be remedied in 2011. In September 2011, this Parliament voted unanimously for profound change of the legal basis of the European school. In the same resolution, this Parliament stated that the current legal basis left our children in, its words, a legal limbo. The European Ombudsman later found that the Commission was guilty of maladministration by not conducting an independent review of the European school. Yet the Commission, in its word, disagrees with the Ombudsman, so it refuses to act on the Ombudsman ruling, and it merely repeats the arguments which failed to convince the European Ombudsman. The European Court of Justice noted that it, and therefore all national courts in Europe, have no jurisdiction over the European schools. I mean, truly a disturbing legal limbo and a disgraceful way for the European schools to operate. So notwithstanding Parliament's resolution calling for profound change and the remedy of the legal limbo, notwithstanding the EU Ombudsman ruling, notwithstanding the ECJ ruling, notwithstanding the ongoing issues with the European school falling standards, this situation continues today with no profound change and a continuing legal limbo for those children harmed when things unfortunately do go wrong at the European schools. The European Commission has stated that reform of the European school is almost complete and is in its final stage. Yet it has and seemingly cannot correct the legal limbo, nor the failing standards, and nothing material is likely to happen in the foreseeable future on these matters unless you MEPs act. Hence, the petition seeks to have an independent look at what can be done. One really has to wonder why the Commission does not want this to happen, flying in the face of Parliament, the European Court of Justice, the European Ombudsman, and parents and children. At the European school, things can and do go wrong, and have gone wrong. That's life. The most important thing is that mistakes are rectified and lessons learned. This simply does not happen in the current European school system because there is no effective oversight. It is immune from criticism and judicial oversight. In effect, in my opinion, anarchy rules. In summer 2012, very significant flaws occurred in the European baccalaureate exams. The matters harmed my daughter and many other pupils. I know of 50 other pupils who were directly harmed. The Commissioner, Vice President Mr. Šefčovič, informed this Parliament in November 13 that concerning European Baccalaureate 2012 exams, and I'm quoting, the Commission regrets the problems encountered in the maths and chemistry exams. The Commission requested a detailed report from the Office of the Secretary-General of the European Schools, which was prepared by independent external experts. Mr. Šefčovič went on to say that a number of recommendations were made that will be followed up closely in order to avoid similar problems in the future. Now, let me put on the record that in relation to chemistry and the problems encountered in 2012, in fact, There was no detailed report provided to the Commission by the Office of the Secretary-General of the European Schools. There was no use of independent external experts to assess the problems. There were no recommendations made, and so, of course, there was in fact no follow-up, and nothing was done to avoid similar problems in the future. Now, I hope you're listening, because here is actually what really did happen. The European School and the Commission, they rely on a report, the so-called Rees report of 19th of July 2012, which I shall give the Chair as evidence, so it has it in front of it. It is 3 paragraphs, in my respectful submission, of irrelevant, frankly nonsense, of no merit to the arguments, and to be candid, it's an embarrassing piece of paper for the schools and the European Commission to rely upon, to say the least. I urge you to look at this 3-paragraph report and ask yourselves, is this truly the best that can be done for our children? It was, by the way, written by the examiner whose work was under scrutiny. It denies any issues, but we know that turkeys don't vote for Christmas. I should add that I have copies of reports from about 30 teachers, written by those teachers to the school authorities in 2012, prior to this 3-paragraph report, with their grave concerns about the problems. Yet the European School and the European Commission are in denial. So the existence of a problem was denied, and in my submission this sloppy 3-paragraph report was used to say that there was no problem, and nothing was done. By the way, the 3-paragraph report was relied upon in so-called legal proceedings, even though it's wholly misleading, inaccurate and inadequate. Pupils who were harmed were denied any effective right of redress, and appeals through the school's so-called legal system were, guess what? Well, they were denied because turkeys don't vote for Christmas. Many children suffered real harm, including my daughter. The problems repeated themselves in 2014, this summer just gone. Now remember Vice President Šefčovič saying there was a detailed external report, actions would be taken to ensure these problems would not happen in the future. They happened again this summer. By some estimates, some 500 pupils had their opportunity of university places put at risk, if not denied. On 1st of July 2014, all the chemistry teachers of the European schools, all of the teachers, not some maverick group, so about 50 teachers in total, they wrote a single letter to force the European school to act. They wrote in stark terms, and this is the teachers commenting on the output of the European school system. They say, you have failed to mention that us as teachers with over 100 years combined experience of teaching chemistry at baccalaureate level in the European schools have complained. They've complained questions were asked that were not on the syllabus. Questions were confusingly worded so the students didn't know how to respond. There were excessive, convoluted mathematical problems. Incorrect answers were given in the marking scheme, and that the marking scheme was inconsistent with prior years. A pretty damning report from the teachers at the time this summer. So in 2014 and in 2012 there were enormous errors and problems, yet the European Commission and the European schools are in denial, and they're not taking any effective steps to remedy the problems nor learn from them for the future. Our children continue to suffer real harm. As I say, in both cases, pupils were really impacted gravely. Many lost their university places, including my daughter. After a decade or more as a top pupil in the sciences in our European schools, our best and brightest European students see their education and career prospects cast aside by incompetence. They're sacrificed on the scrap heap of bureaucratic and legal limbo. And so, yes, mistakes are made.
Excuse me, could you please come to an end, because we're running short and we have many more speakers.
I'm almost finished. So we must accept that mistakes are made, but we must also expect that they are addressed and remedies put in place. This is one of the most important European institutions, one which all European institution staff entrust their children for education. Yet, when things go wrong, there's no effective remedy. And remember, Parliament in 2011 found a legal limbo and said it needed to be redressed. There's no independent oversight and there's no legal system applying to the European schools, and the ECJ and normal courts in the Member States have no jurisdiction. So, and I will conclude, Chairman, The European Commission, despite funding the European schools to the tune of some 300 million in 2013, also state that they merely have one vote among 29, the other 28 being the member states. So the European Commission cannot act on its own. So unless you MEPs demand action, nothing will happen. Nothing has happened and nothing will happen. Let me conclude. There's an obvious problem harming our children. You found this in Parliament in 2011. The Ombudsman found so. The European Court of Justice found so. And yet it's clear that the European schools, not being subject to effective EU legal oversight, has made and continues to make some serious mistakes. These mistakes have serious negative consequences, including on my daughter, and these mistakes are continuing. So what does it take to get a remedy to this? Profound change has not and will not happen unless we now insist. Unless we do, these problems will persist, and that's why I put forward this petition. The harm that has happened to children, including my daughter, must be prevented from happening to others, including, God forbid, any of yours. Let's lance the boil of this arcane 1957 legal basis of the European schools and create a better European schools for our children, for your children. To do so, we need to understand the issues and the steps needed to fix them, and that's what's requested in the petition. An independent review cannot now be too much to ask for. So I thank you for your time, and I do hope you'll support the petition.
Thank you very much. Actually, I can assure you that in 2011, I was the coordinator in the legal affairs. I was the rapporteur for the legal basis for the European schools as an opinion to the Cavada report in the Cultural Committee. We know, many of us, the whole issue, and it must be, every detail must not this evening be reiterated. Can I now turn to Per Moles?
Sorry, 1 minute, very brief.
Very, very brief, because your colleague has really taken a lot of the speaking time slot.
Gracias, señora presidenta.
Yes, thank you very much, Madam Chairman. We've got Sarah Konya-Barbers, who's the president of the Parents Association across the European schools. I am the president of the Association of Parents from Brussels 1. In 2011, there were almost 1,500 signatories protested about the budget cuts being made to the budgets of the European schools, cuts of €7 million. This has led to a reform of the European school system, essentially to save money, to make costs, and without any kind of serious pedagogical analysis. So the question is, 3 years down the line, is there any point to this petition? And the reply is, well, yes, because there hasn't been any kind of evaluation or assessment as to the consequences of the reform. As I said, there has been no kind of pedagogical analysis as to the consequences and the impact of the new measures that have been introduced. And we find ourselves in situations now where the courses of mathematics are reduced from 6 to 4 periods a week because the number of pupils does not justify being able to give all the classes. And then we find ourselves that where certain groups of pupils have to be merged together in order to meet the new requirements. And we feel that any replies given to our questions have been unsatisfactory to date. One would also have to bear in mind that the budget reform and the budget cuts have not solved the situation in the European schools. We find ourselves in a never-ending spiral of problems, problems which are getting worse over time. On the one hand, we see that the member states have stopped seconding teachers to the European schools, and as a result of this, the European Commission has had to increase its budgetary contribution to the European schools in order to recruit teachers locally. This has a direct impact, obviously, on the European Union budget, but at the same time it questions the educational balance of the European schools because the locally recruited teachers don't have any kind of inspection system, teacher inspection system, as is the case for those teachers that are seconded from the member states. And at the moment, there is a dispute ongoing between the Commission, the European Central Bank, the European Investment Bank, as to who should actually be funding the European Union's contribution to the European school system. This is a discussion that has been going on for some time, and we very much hope that there will be an answer to this. As I said, these problems were raised in 2011, but we feel that it's not going to be possible to solve the problems by having an approach where you just sort of patch up each of the individual small problems. We feel that the European Parliament should try and promote a different approach for the European schools so that we can respect the underlying principles of the European schools and the kind of teaching they provide. Thank you.
I think that I will give the floor to the Secretary General of the European Schools at this point to respond to what has just been said.
So, good afternoon, ladies and gentlemen. You have heard the two speakers highlighting the problems in the European schools. Indeed, we have to look at the mirror. We are not a perfect organization and we can improve. We have received a lot of advice, recommendations, and the Board of Governors, the Board of Inspectors, and different preparatory boards in our system are reflecting on that. And if we are starting with Mr. Ryan's petitions about the legal limbo, I can inform the board today that the Board of Governors have discussed the so-called Kavada report, and it has made several actions related to the recommendations of Mr. Kavada. One of them that we have created a legal working group, which is at this moment analyzing the legal situation of the European school. In the working group, it will have the next meeting tomorrow. There is the president of our complaints board, but also the European Commission, European Court of Justice represented, and it's discussing how to improve the legal situation in the European school system. It's too early to say what will be the recommendations of that working group, but without any doubt the Board of Governors will take them seriously. What comes to the legal non-existing framework, we disagree, and I would like to ask my legal assistant to make a very precise statement about our legal status. So if you would allow, I would give the floor to Madame Laurence Bernard.
Voilà, bonsoir. Alors, pour les écoles européennes, la pétition...
Thank you very much. The Paul Ryan's petition is based on legal assumptions which are inaccurate. It's not correct to say that European schools do not respect the principles of community law. There is, within the system, the so-called Chamber of Recourse, and this is an administrative body which is independent with the job of looking at appeals against administrative acts by the school. And the Chamber of Recourse bases itself on the rules specific to European schools, but also on the basic principles informing the EU legal order. And this comes from the constant case law of the Chamber, whereby it's the treaties informing, it's the principles informing the legal order. They are bound, irrespective of that, to respect the general principles. And the cases taken to the Chamber of Recourse are based on the principles such as equal treatment and non-discrimination, the principle of equality and proportionality, protection of legitimate expectations, and the right to enjoy effective jurisdictional protection. With regard to jurisdictional protection, the petitioner feels that is inadequate within the system of European schools. Nonetheless, we cannot subscribe to that analysis. It is true that in the past that jurisdictional protection has not been optimal in the sense that a number of acts by the school were not liable to recourse. In the meanwhile, there is ever more scope for appeals, and the scope has widened out in order to provide for effective jurisdictional defence. Could you try to wrap up?
5 more minutes. So, d'accord. En gros, non seulement...
So, grosso modo, not only have the European schools respected the basic principles of community law, but in addition, they have their own jurisdiction and their own rules, with a whole range of possibilities for recourse and appeal. And if the Chamber of Recourse is not competent, the plaintiffs can go to national court. And this is not a legal vacuum.
Petition by Manuel Altemir Merreglina on discrimination. Could you just very, very, very briefly, because we know the petition, you don't need to introduce it from the beginning till the end, just with a few words say your outmost meaning and feeling.
Thank you. I'll be very brief in that case. As you are aware of the problem and of the petition, it's a problem that I think everybody is aware with. Both the Commission, because they refer to this problem in their replies. There have been European Parliament reports dating back to 2008, where it's quite clear and can be seen that Spanish students of the European schools don't go very often to Spain to study at Spanish universities. And the reason for this is that I feel that there is discrimination. The Spanish authorities apply certain conversion methods to convert the marks that Spanish pupils get at the European schools, and basically they're brought down. And these are when they convert them to the marks that they need to have access to Spanish universities. This is an issue that is touched upon in the report from the Secretary General of the European Schools. And if a pupil wants to go to a university where there is a limited number of places, then there's a kind of entrance or aptitude exam. And in certain cases, there are questions about subjects that the Spanish pupils of the European schools have not covered as part of their curriculum, so obviously they are at a disadvantage. The European Commission has said that the member states are responsible for organising or setting up their own education systems. I agree. But obviously, as long as they respect the principle of non-discrimination, and I feel that here they are not respecting that principle. And what is more, in order to be able to do these entrance exams, which are not compulsory, but which are necessary if you want to study medicine, or in any of the degree courses where there's a limited number of places, the dates of these entrance and aptitude exams are at the same time as the exams for the European Baccalaureate here at the European schools. So this is just not possible. We have tried to sort out this problem together with the Spanish authorities and have tried to do so for many, many years, but to no avail. The European Commission recognises that there is a problem, but then say there is no obvious discrimination. But I feel that there is obvious discrimination. Firstly, when they apply these conversion formulae for the marks, and then also when it comes to the dates when they organise the entrance exams. Over the past 2 years, the situation has got even worse, because greater power has been conferred upon the universities to adopt the kind of entrance rules that they deem fit, which means that now we are in a bit of a limbo, because the universities haven't actually adopted any rules, which means that pupils from the European schools don't really know what kind of regime or system is to apply to them. I think that's a brief summary. Thank you very much, says the Chair.
Dad, would you like to take the floor on this?
Very briefly. I'd like to start off by saying that we would have to realise that the European schools should not be seen as a privilege, because to a certain extent they are seen as a privilege for the staff of the European unions. This is a right and entitlement for all those officials and staff who work for the European institutions, and rather than a right, it is a service which is there for the staff. In certain cases, staff are here for only a limited period of time, and obviously if we're not able to guarantee education of our children, then it's going to be extremely difficult for us to be more mobile, to move around, which is to the detriment of the European institutions. So as I said, this should be seen as a service, and I don't think we should find ourselves in a situation where children from these schools are being discriminated against. Obviously, it's a question of commitment and will on the part of the member states. We've heard that certain member states are reducing their financial contributions, but I feel that there has to be proper recognition of the member states of the schools, and there has to be a proper financial commitment. We know that the member states second teachers to the European schools, but there has to be a control and inspection of this as well. And what I think is missing is that there is a clear recognition of the European school system by certain member states. So the children, the pupils are suffering not only because of the budget cuts. Something else I think is of concern. Obviously, the budget cuts are being made in other member states to their national education systems as well. But we've heard from one of the petitioners that there is a problem with that recognition of the qualifications and the marks that are given at the European schools. And obviously, this could have an impact on access to different kinds of university degrees. So I think we have to continue to work to ensure that there's proper recognition of the European school system by the member states and that there is no discrimination for pupils from these schools.
Yeah. Peter Jahr.
Ganz kurze Anmerkung, Frau Vorsitzende. Sie haben
Just a quick point. You said, Madam Chair, 2011, the Parliament adopted a motion for a resolution on the European schools. That's quite correct. But I would urge, at least we've got to accept the fact that the decision by the Parliament, that resolution has been implemented in a suboptimal way. I think that's clear for all to see. And I think that's something which we've, at the time, I remember, the European schools are a kind of forgotten child. And it's simply being allowed to, as it were, to fester. And I think this is something we've got to send to the Commission and to Council, and we should forward to them that resolution from the European Parliament. Now, secondly, I've been, of course, when it comes to universities, they can have an aptitude test, but then it's got to be, they can check, for example, that you speak German, but of course you cannot have discrimination. It's got to be a test which applies to everyone. And when it says here that there are talks or negotiations with the Spanish authorities and they've sorted things out, but we've got to know, is there still discrimination or not? If there is a test, fine, but it's got to be for everyone. But you can't say, no, you come from that school or from that region, and you're going to be marked down. That is not on. Now, I know that time is short, but that's I think that we've got to simply leave the petitions open. And in particular here, when it comes to the Spanish dimension, Spanish authorities, what state of advancement do we have in the discussions between the Commission and the Spanish authorities? Because the Commission has suggested that that discrimination has been all but removed. But I'm not sure if that is the case. We've not had time to get to the bottom of this. And I think we'll need to get a bit more detail with regard to the response vis-à-vis the Spanish authorities. Thank you very much.
That we are losing our interpreters quite quickly. I would propose the following, that we come back to this with the Commission at a later stage, because what we simply see here is that we need to address this a bit broader. By letter, like a follow-up to the Cavada report, we could write a letter to the Cultural Committee from this committee. We could also reach out to the Council and to the Commission once more and ask them to come back with detailed information on how they intend to proceed, because the children are our future. We need really to make sure that they are safe and that they can, and secure. And also, from a legal point of view, we need to find a solid legal base for the European schools, which is crucial, as every other European institution. Monsieur Martin, vous avez demandé la parole, s'il vous plaît.
Mr. Martin, you still wanted to take the floor, did you? Yes, Madam Chairman, I agree with you. I think the petition should remain open. I think we should go into it in greater depth. I certainly need to. On that last point, I'd like to know, is this a standalone case, or are there other similar cases? we can't really expect member state universities to adapt to the European school examination system. It should be the other way round. Isn't it possibly necessary for the European schools to adapt, to give their alumni equality of opportunity when it comes to university entrance exams? Do the European schools have figures? Do we know if this has occurred previously elsewhere, or is this a one-off case?
Please.
Por la premura.
Thank you. Well, very urgently, rather quickly, this report to the Council, perhaps it could make a reference to the specific features of Spain and their system. It shouldn't only refer to the European school system, but perhaps we should have a reference to the way in which the European school system is recognised in Spain and the problems that we've heard from the petitioner.
Mr. Kivinen.
Very shortly. The European Baccalaureate is well recognised in member states, and we get our pupils in the universities really well. Indeed, it would be interesting to make more study about it. The European Parliament has made a study about it some years ago. It's available still for you to be read. The problem of Spain is related to our marking scale, which is from 60 to 100, or 0 to 100, and 60 is the passing rate, when in Spain it's 50. And indeed, there are pupils who are a bit downgraded, however we are looking at it. It has been tried to solve by all our possible contacts with the Spanish Ministry of Education. And I have to point out that Spain is part of the European school system. The Spanish inspectors are involved in the European Baccalaureate, and that makes our Baccalaureate a bit different than any other national system of abroad. So we could hope that there would be common understanding in Spain so that we could have a solution. Our Board of Governors, nevertheless, has created an assessment working group, and we are looking at the assessment in a general, and last month in the teaching committee, the working group made first proposals. They were asked to study a little bit more, make it more precise, and we are most probably changing our marking grades to be more in line with the European credit transfer system and the European standards. There are only one country which have a similar type of marking system than we have at this moment, and it's Italy. So we are working on that. But it would be good to have Spain respecting our standards.
Excellent. Can I do the following, propose the following? As I respect the Commission very highly, and I'm completely sure that you have taken note of everything that has been said, why don't we do the following? That the Commission come back to the Petitions Committee in written with, if you have any additional information or any additional proposals that you would like to do. And also, when this assessment group that you, Mr. General, Secretary General, is talking about, the assessment group, when the proposals are ready, why don't you forward them to the Petitions Committee? And then we can look through the whole thing and come back to the petitioners in due time. Is that a possible way forward? The colleague seems to like the idea. I am not I'm not totally convinced that the Commission is happy about this. But what can we do? We are losing the interpreters in 30 seconds.
Yes.
So we'll have a written procedure.
Madam, very well to come back. This subject is very challenging, and I think that it is very good that this committee will deal with it again. However, there is one point, the point 19, so the petitions of Mrs. Barbara Mazurkiewicz-Zaleska and the one of the 1,356 parents of the schools concerning the so-called budget cuts of 2011, that, I have come also to discuss this subject. By the way, there is a problem, let's say, in the request itself, because there were no cuts. There was an increase of 6.5% of the budget. There was a request of 11% increase. The budgetary authority, not the Commission, that asked for 11%,
the budgetary authority reduced the 11% to 6.5, so there were anyway no cuts. And this, as far as this petition, these two petitions are concerned, we would really like that the procedure would be closed. Thank you.
I think that this petition, you have responded to it properly, and we all live in times of austerity. We know what it means. And there is no reason that you give us any additional. I mean, you have already reached out to us with the information, but we will handle all these petitions together and follow up subsequently. Thank you for your quick and very accurate response, though. And now, colleagues, I wish you all a very good evening. It has been a very long day, and I assume that you are as exhausted as I am. But tomorrow is a new day full of new opportunities. Have a nice evening.